Texas, and I proudly call it my home, but I've never owned a gun. I've never shot a gun, but I've lived in households where guns were owned. Three of my uncles served in the military, two in a police capacity. And in addition to that, I have had either the privilege or the burden, it depends on your perspective and certainly my feelings on a particular day, of representing 9 individuals on Texas death row, all of whom have used guns to commit crimes that resulted in the loss of life. Of those 9, 4 have already been executed, but 5 remain under my care, and I zealously represent their rights under the Constitution. So while I'm somewhat agnostic about guns, I'm extremely passionate about the United States Constitution. I have the privilege of being on this panel about a legislative response. How many of you in this room think the legislative response has been effective to gun violence? Okay, I'm seeing not a single hand. How many of you think the judicial response has been effective? Once again, no takers. I think I'm in agreement with you. And unfortunately, drastic times require drastic measures. I spoke to a couple of my colleagues before this panel began, and I realized that we haven't reached a threshold in this country about gun violence, and that's rather shocking to me. When Gabrielle Giffords was shot, and there was loss of life that day when she was simply out serving her constituents, I thought that that would motivate all of us to have a very serious conversation. Afterwards, in Colorado, there was another mass shooting in a movie theater. So in the first scenario, you're going to see your local representative. In the second, you're going to enjoy entertainment. And in both instances, many lives were taken. And in the third final one that's particularly unique in impacting this community, I thought surely when innocent lives are taken at an elementary school, we would get serious about this conversation. We're going to dress it up in the Second Amendment, but I'm going to give you a mini constitutional lesson that actually your governor has already actively conveyed. Number one, there's not a single amendment that is absolute. The United States Supreme Court articulates that in many of its cases, whether it's the First Amendment or even the Second Amendment. And this is a point on which all 9 justices agree. No constitutional right is sacred. I think the Second Amendment is misunderstood, and I think it's time today, in our drastic measures, to repeal and replace that Second Amendment. While I came in here originally thinking that was a little shocking, I feel a lot better having heard your governor talk about what your state's doing, because my solution actually is not all that revolutionary. Your governor stood here and proudly talked about what Connecticut is doing to deal with gun violence. I am going to propose a states' rights model, that we allow the Constitution, we modernize it, we allow it to do what it's intended to do, which is to allow variety among the states. While your governor wants to restrict guns, I live in a state where my governor not only wants and expects prevalent gun ownership, but we're actually having legislation passed that allows individuals to have concealed license permits, something that was never, ever allowed in the 18th and 19th century. But now, my governor and my legislature want to allow students at the college and graduate level to have their concealed weapon with them in the classroom. And the beauty of a states' rights model solution is it allows those of you who want to live in a state with strong restrictions to do so, and those who want to live in a state that have very loose restrictions to do so. But now I'm going to move forward and give you some of the history, because I think most people who talk about their Second Amendment rights are probably very unfamiliar with what the Second Amendment says. How many of you have actually read the Constitution? Excellent. I would expect in a law school that's nearly everybody. How many of you have read and studied the Second Amendment? Lots of you. That's why we're all here today. This is the beginning of the paper I wrote and provided to the University of Connecticut here. It says the Second Amendment is a mere 27 words, though most people only recognize 14 of them. A well-regulated militia, and there's a comma after that, being necessary to the security of a free state, comma, The right of the people to keep and bear arms shall not be infringed. Now, somehow in this conversation, the beginning of that protection is lost. What do these words taken together really mean? And do they mean something different today than they did in the 18th century when they were first written, debated, rewritten, and ultimately ratified? What does the Second Amendment really protect? I would urge that in studying and interpreting the Second Amendment, we have moved from the 4,543 words of the Constitution to the 27, and now we're stuck at 14. How hard is it to work with a document that was created in the 18th century? This may also sound radical, but when I teach my constitutional law class, usually the largest textbook in a law school, I tell them I'm in favor of redrafting the entire Constitution. Why? What do we still use from the 18th century? Do we use housing? Do we have the same kind of housing, transportation, medicine, food preparation, plumbing, communications, fashion? Not even weaponry that was envisioned under the Second Amendment do we use with any similarity today. Legal codes? Absolutely not. Slavery is gone. Women are treated differently. Native Americans are treated differently. Entertainment? We had to ask when we started, please turn off your cell phones. I always find that curious. Everyone carries a phone. Banking? No. You can probably use that phone in one of breaks day to conduct some banking. So why do we keep such an allegiance to a constitution that was driven by 18th century concerns? How many of you recognize that the main concern of the 18th century was a standing army? That's what motivated the Second Amendment, fear of a standing army. What do you think the framers would think of the United States in its many locations doing that which we do? And I'm proud of what we do. Please don't mistake my comment. What I'm trying to suggest is these are different times. And I think being wedded to a document, particularly a provision of a document that was drafted in the 18th century to deal with 18th century concerns, has far outlived its usefulness. And it's time for us to consider redrafting a Second Amendment that actually bears context in the 21st Amendment. We don't have militias. Why are we dealing with an amendment that has militias? How many of you have ever seen a case or thought about the Third Amendment? Housing soldiers in homes. Maybe that's happened in Connecticut. We have a lot of military bases in Texas. No one's ever asked to sleep over on my couch. Here's our Second Amendment, and my question is, do these words really matter? Still, a well-regulated militia being necessary to the security of a free state. Is this the prefatory clause, as Justice Scalia suggests in Heller, or the operative clause, which he looks at the second part of the Second Amendment, and four justices see this as the operative clause. Because there's not a word in the Constitution, at least when we're doing our interpretation, that we should take for granted. Every one of those words, though there's less than 5,000, were extremely deliberate in their crafting. So in 2008, for the first time ever, the United States Supreme Court said the core or central right of the Second Amendment was handgun possession in the home for personal safety. I look at the Second Amendment, I don't see that, literally. And I find it somewhat odd that the more textualist, originalist folks on the court found it to be so. But to be fair in my criticism, I find it equally odd that the usual federal government folks and individual rights, big government, big individual rights, said no, nobody gets to have a gun in their home. So there was a flipping of the court in what's their traditional judicial philosophy. I think what causes that is our frustration and inability to put 18th century words into operation when we're talking about semi-automatic rifles in a theater. Do you realize that this year we finally have a convergence of statistics? It is more likely in 2014 that you will be the victim of gun violence, whether through suicide or homicide, as one of my colleagues has mentioned, 99% of the cases, than you will lose your life in a car accident. Why? We have demanded consistently that cars become safer. We recognize that as people travel at speeds that are great, commute to work. I don't know if you have public transit in Texas. We don't believe in it. It's just not our style. We're pretty independent. I drive 51 miles to work one way in my own car. Chances are much higher that I will die in gun violence than on the roadways of Texas. I think that's an important consideration for us to realize. I also put in my paper that for all the cries of constitutional heritage, one thing is certain: the Second Amendment right to keep and bear arms was nowhere cataloged in the Declaration of Independence as a grievance against King George III. That's intriguing, isn't it? It wasn't part of the impetus for our American Revolution. The Third Amendment's quartering of soldiers was clearly articulated both in the rough draft and final format. The threat posed by standing armies was mentioned, and I'm telling you a driving force behind the Second Amendment. There are even comments regarding the slave trade. Jefferson later omitted, but for all the claims of historical pedigree, the so-called individual right to keep and bear arms, currently disconnected from its contextual affiliation with the militia, was apparently not the impetus for calling forth the American Revolution. 1874, gun ownership not an individual right. 1886, same thing. There are only 5 cases decided by the United States Supreme Court. The first 3 connect both ownership and weaponry to the militia. United States versus Miller, 1939. Now, you can try to distinguish them away, but that's really not proper interpretation because, in fact, these 3 cases do tie gun possession and ownership to military-style weapons, which is ironic. Now we want to regulate away military-style weapons. Well, that's what the founders wanted, was military-style weapons in people's possession. Where does it leave us today? Well, I don't know that the militia clause is relevant, certainly not after Heller. Second Amendment only applies to the federal government. The Second Amendment certainly nowhere in history anywhere else talked about hunters or sportsmen. I've run out of time, so the only thing I'd like to do is leave you with my proposal. My solution goes through the Article 5 process. And for those of you who haven't studied Article 5, it's not simply requiring our federal legislature, which seems to be failing us all, to set forth the amendment. Rather, you can go through the state's model. My proposal, and I'm just going to briefly go over it without walking you through all the words, is to return to the states the power to primarily regulate. The only weaponry that would stay in the hands of federal regulation would be military weaponry. Do I think this is going to happen? No. Do I think it's a better solution than the legislative response? Absolutely. Thank you very much.